Donald Trump's case in Washington, D.C. comes to a head as the appellate court rules against the former president. We will get into who these judges are, what the ruling is, and we will see what we'll go over a video of what Fox News has to say about the ruling. All of this next, because this is common sense.
Common sense told us that when you put a big tax on something, the people will produce less of it. So we cut the people's tax rates, and the people produced more than ever before. The economy bloomed like a plant that had been cut back and could now grow quicker and stronger.
Welcome, everyone. This is the Common Sense Conservative coming to you with a common sense take on what just transpired yesterday in the Trump appeal about the presidential immunity and what was going on January 6th and what has come out from this appellate court. So, first thing I want to go over real quick is who are the judges that ruled against Donald Trump in the appellate court, and the three judges is Judge Henderson, Judge Childs, and Judge Pan. Um, let's go over real quick just who these judges are. So, in August of 2022, Judge Henderson did a ruling that delivered a setback to Mr. Trump and allowed the House to access Mr. Trump's tax record. But in a separate opinion, she expressed unease about Congress's potential and incentive to threaten a sitting president with a post-presidency request for tax returns in order to influence the president while in office. So essentially what she is saying is like, hey, I ruled with the rest of them, but I'm very uneasy about Congress, which in 2022, August of 2022, was still controlled by the Democrats. It was turned Republican, I believe, in the election cycle of that year. And so now let's go over the remaining judges. The remaining judges on the panel, J. Michelle Childs and Florence Y. Pan, are too new to have played a major role in any of the previous Trump-related cases, but both were appointed to the appeals court by President Biden in 2022, although they had extensive judicial experience in the lower courts. So these two judges were appointed by President Biden, which in my opinion is a conflict of interest. The president that's running for re-election now, it has appointed two judges that are overseeing the top political opponent of the current sitting president in a case about insurrection on January 6th. So Judge Child served as state court. So this is Judge Child. Served as a state court judge as well as a federal district court judge in South Carolina. She attracted national attention in 2022 because she was on a short list of potential nominees to fill a Supreme Court vacancy, although Mr. Biden ultimately picked Justice Kenya Brown Jackson. Personally, to me, and once again, all my opinions, but just looking at this through a common sense take, Judge Childs was on the short list to become a Supreme Court judge, right, which is appointed by the president, but she wasn't selected. So common sense tells me that this is a conflict of interest, that this woman said, hey, I didn't make it that last time, but if I rule in favor or against Trump this time, maybe the next time a Supreme Court position opens up and Mr. Biden, basically, I scratch your back, you scratch mine. A supporter of Judge Child's heralded experience that would have added even more diversity to the court. So instead of, and this is what I hate about the diversity claims. Instead of putting the best person, whether man, woman, black, white, green, purple, orange, blue, whatever, it's diversity to the court. So she should have been appointed, but whatever. A blue collar background and a degree from the University of South Carolina Law School. Some progressive groups criticized the fact that she had once worked for a law firm that defended employers in worker discrimination and sexual harassment cases. For her part, Judge Pan served as a trial judge in the equivalent of the state court system in the District of Columbia, so she's been a trial judge in D.C. from 2009 to 2021. In 2016, President Barack Obama tried to elevate her to the federal district court for the District of Columbia, but Senate Republicans did not act on her nomination. Once again, another conflict of interest, in my opinion. It's, hey, we tried to get you up to the federal district court, a higher court than what she was in. She was a trial judge to a federal district court, but Senate Republicans at the time, which is in 2016, was the Senate was controlled by Republicans during Barack Obama's term, and the Republicans didn't. So therefore, maybe she harbors some ill will towards the Republicans. So Judge Pan has twice been promoted to in Justice Jackson's wake. In 2021, when Justice Jackson was elevated to the D.C. Circuit from the federal district court, Judge Pan filled the subsequent vacancy. And in 2022, once Justice Jackson was confirmed to the Supreme Court, Judge Pan stepped in, this time to fill the D.C. Circuit seat. Judge Pan, a child of Taiwanese immigrants, is the first Asian American woman. Here we go. You can tell this is the New York Times because instead of stating that her accolades, it's she's an Asian American woman that's serving the D.C. Circuit. What's that got to do with the price of tea in China? That's what I'm wondering. She graduated from Stanford Law School and clerked for 2 Republican appointed federal judges in New York. She worked for several government positions before becoming a judge, including 10 years as a federal prosecutor. So now we know a little bit of something about the judges, and in my personal opinion, all 3 of them, quite frankly, are. This one says she's complicit, even though she feels that Congress presents the potential and incentive to threaten a sitting president, but she's like, I'm going to rule with them anyway. And this happened in 2022, so after President Trump's first term. And then these 2 were, this one was rejected by Biden, chose somebody else chosen over her. So, hey, maybe you want to get in his good graces. And this one was rejected by Republicans. So, yeah. So let's get into what their actual ruling is. Make this real quick. So Donald J. Trump, this is their ruling, as you can see right here, the United States of Appeals from the Districts of Columbia Circuit, which we all know is a big, big Democrat stronghold. So anyway, and here's the judges that sat on the trial, or they're all circuit judges. So opinion for the court filed per curiam. Donald J. Trump was elected the 45th President of the United States on November 8, 2016. He was sworn into office at noon on January 20, 2017, and served until his term expired on noon on January 20, 2021. At that moment, President Trump became former President Trump, and his successor, Joseph R. Biden, became president and began his own 4-year term. U.S. blah, blah, blah. Although this sequence is set by the Constitution, it did not proceed peacefully. So I do believe on January 20th, he turned over power to Biden. What's in question in the Jack Smith case is the January 6th insurrection. I'm pretty sure that's where we're at on that. But anyway, indeed, from Election Day 2024, the government alleges that President Trump denied that he had lost his bid for a second term, which is his right. I mean, Hillary Clinton still doesn't believe she lost from 2016. That one woman up in Georgia don't believe she's lost from 2020 or 2012, the governorship. So people challenge elections all the time, just saying. 2020, and the government alleged that President Trump denied that he had lost his bid for a second term and challenged the election results through litigation, pressure on state and federal officers, the organization of an alternate slate of electors, and other means. He alleged his alleged interference in the constitutionality prescribed sequence culminated with the Washington, D.C. rally held on January 6th. So 14 days before the 20th in the transfer of power, the day set by the Electoral Count Act 3 U.S.C. 15A for the Congress to meet in joint sessions to certify the election results. The rally headlined by President Trump resulted in a march of thousands of people. You know, the march where he said, I know you're all about to walk or go peacefully down to the Capitol and make your voices heard, which I don't recall that saying, hey, breach the Capitol, but whatever. Uh, Violent breach of the Capitol building. A violent breach that was, you know, documented thousands of times in video of police letting them in, them walking through the Capitol, staying within the ropes. What the one guy put his foot up on Nancy Pelosi's desk, but whatever. Um, So yeah, the breach delayed congressional proceedings for several hours, and it was not until the early morning of January 7th that the 2020 presidential election results were certified. So still, while Trump is president, and what he's arguing here is presidential immunity. All right, election results were certified, naming Joseph R. Biden, the man that can't put four sentences together, as the soon to be 46th president. Since then, hundreds of people who breached the Capitol on January 6, 2020 have been prosecuted in prison without a trial and without proper defense, but we won't go there. And on August 1st, 2023, so 2 years later, in Washington, D.C., former President Trump was charged in a four-count indictment as a result of his action challenging the election results and interfering with the sequence set forth in the Constitution for the transfer of power from one president to the next. Former President Trump moved to dismiss the indictment, and the district court denied its motion. Today, we affirm that denial for the purpose of the criminal case. Former President Trump has become a citizen Trump. So, mind you, they didn't bring these charges like articles of impeachment from January 6th to the 20th. They waited 2 years in August 1st of 2023, which everyone knows around August, September, October of the year preceding a presidential election. That's when you're starting to campaign. That's when you start to announce that you intend to run for office. That's whenever they brought these indictments. They found out Trump was going to run for office, and they said, "Oh crap, we got a bumbling fool up here." So yeah, Trump's just going to wipe the floor with him. For the purpose of the criminal case, former President Trump has become a citizen with all the defenses of any other criminal defendant by any executive. But any executive immunity that may have protected him while he served as president no longer protects him against this prosecution. So everyone says the president doesn't have immunity. No, they stated here, but any executive immunity that may have protected him while he served as president no longer protects him against this prosecution. So they said, hey, once you no longer president, you're no longer protected, is essentially what they're saying. So, and then it goes into the background. I'm not going to read all 57 pages here. We'll be here all day. This would be a 2-hour video. But let's just go and see what. Oh, right here is what they said. The District of Columbia federal grand jury indicted former President Trump on 4 criminal counts arising from the steps he allegedly took to change the outcome of the election. And here's what the 4 counts are: conspiracy to defraud the United States by overturning the election results in violation of 18 U.S.C. 371, conspiracy to obstruct an official proceeding, the Congress certification of electoral votes in violation of 18 U.S.C. 1512K, obstruction of an attempt to obstruct the certification of electoral vote in violation of this one, and number 4, conspiracy against the rights of one or more persons to vote and to have their votes counted. in violation, blah, blah, blah. At this stage of the prosecution, we assume that the allegations set forth in the indictments are true. We emphasize that whether the indictment's allegations are supported by evidence sufficient to sustain conviction must be determined at a later stage of the prosecution. And last thing we'll read real quick. The indictment alleges that former President Trump understood that he had lost the election and that the election results were legitimate, but that he nevertheless has determined to remain in power. Indictment number 2, he then conspired with others to cast doubt on the election's outcome and contrived to have himself declared the winner. The indictment charges that he and his co-conspirator allegedly advanced their goal through 5 primary means. First, they used knowingly false claims of election fraud. That's not been proven that they were knowingly false. An attempt to persuade state electors and election officials to change each state's electoral votes in former President Trump's favor. The more than 10,000 dead voters had voted in Georgia, that there had been 205,000 more votes than voters in Pennsylvania, that more than 30,000 non-citizens had voted in Arizona, and that voting machines had switched votes from Trump to Biden. Okay, so, as somebody that follows this religiously and has decided to start making videos because I can no longer stand the narratives being pushed out there. The dead voters that voted in Georgia, that's been shown, like on several different news outlets, that, hey, where do these votes come from and how come this person who's been dead for 10 years has casted a vote? There were more than 205,000 more votes than voters in Pennsylvania. Well, that's easy to count. Let's see who the registered voters in Pennsylvania are and how many votes came in. More than 30,000 non-citizens had voted in Arizona. Well, you would have to just look at registered voters and look at the names on the ballots, which they won't do, and that voting machines had switched votes from Trump to Biden. A little bit harder to prove. Because if a machine does it, there's no paper ballot to do it. Second, then President Trump and his co-conspirator organized fraudulent slates of electors in 7 targeted states, attempting to mimic the procedures that the legitimate electors were supposed to follow. Then caused these fraudulent electors to transmit their false certifications to the vice president and other government officials to be counted at the certification proceeding on January 6th. Third, then President Trump and his co-conspirators pressed officials in the Department of Justice to conduct sham election crime investigations and to send a letter to the targeted states that falsely claimed that the Justice Department had identified significant concerns that may have impacted the election outcome. And fourth, then President Trump and his co-conspirators attempted to convince the Vice President Mike Pence to use his ceremonial role at the January 6th certification proceeding to fraudulently alter the election results. Indictment, whatever. When the Vice President rebuffed them, he stirred his base of supporters to increase pressure on the Vice President. Ultimately, the morning of January 6, 2020, he held a rally in Washington, D.C., where he repeatedly knowingly false claims of election fraud to gather supporters and directed them to the Capitol to obstruct the certification proceeding. I don't recall him ever saying, go down there and stop these proceedings, but whatever, and assert pressure on the Vice President to take a fraudulent action he had previously refused. All right, so there's that, and we're just going to end this video. Trump team vows to appeal court ruling on immunity.
He will appeal a ruling that came down today that says he does not have immunity against charges of election interference. Special counsel Jack Smith asked the Supreme Court to fast track the case. The justices said no to that. They pushed it to the lower D.C. court, which is normal procedure to ask them to weigh in first. The legal battle has already put the trial on hold. It was set to begin next month in Washington. So what does all this mean for the former president and for the election? Let's bring in former Assistant U.S. Attorney Andy McCarthy, a Fox News contributor. Andy, always good to have you with us. It's a 57-page decision by a 3-panel group of judges that include one Trump appointee and two Biden appointees on this three-panel system. And one of the things that they said.
First off, that's wrong. We just saw where the, hold on. See, people, man. A little bit of research. Judge, here we go. Karen Henderson, a graduate of the University of North Carolina Law School, joined the Court of Appeals for the District of Columbia, nominated by President George W. Bush. I'm just saying. In 1990 by George W. Bush, not Trump. All right. Sorry.
Is, quote, former President Trump's stance, meaning complete immunity basically for presidents, would collapse our system of separated powers by placing the president beyond the reach of all three branches. What do you think about this decision, Andy?
Well, the panel did a very thorough rejection of President Trump's position that he is immune from federal prosecution. It made a distinction between discretionary acts that a president takes, such as, granting a pardon, which they accept that a court has no business reviewing, but they distinguish that from ministerial acts or private acts where a president is basically in the position of following the congressional laws that he takes an oath of office to uphold. And on grounds of constitutional law and policy, they looked at the prior rulings, and even though the Supreme Court has never resolved this precise question, they made a very convincing case that I don't think too many people are surprised by, that the president doesn't have immunity.
So let's put up on the board the Trump campaign courtroom calendar. It is very extensive. And I'm wondering what you think, what the impact is on the timing of all of this, and whether or not we will see any January 6th case happen before the election, and whether the Supreme Court is going to deal with this issue in the interim. Andy.
Yeah. So, Martha, very interestingly, probably just as important in some ways as the 57-page opinion from the court is this short one-page order that it issued, which basically says, if Trump wants to try to now take the next step of appealing to the full circuit en banc, as they say, all 11 judges, he can do that, but they are not going to continue to keep the case away from Judge Chutkan if he decides to go that route. So what the court basically said to the former president is, you have until Monday to appeal to the Supreme Court. And if you do that, then we'll hold the case in abeyance away from the district judge, Judge Chutkan, until the Supreme Court decides whether to take the case or not. So the court is aware that the president or the former president wants to delay things, and it's kind of cutting out that middle step. It doesn't mean that Trump can't try it, just means that the case will go back to Judge Chutkan and she can start holding pretrial hearings and the like. That makes it a lot more likely that this case could get to trial. But the other moving part here is that the Supreme Court is going to consider the obstruction statute in connection with some of the January 6th cases. We won't get a ruling on that until the end of June. So as a practical matter, I don't think she could start the case prior to then. And depending on what they do with that case, it could require a big overhaul of Jack Smith's indictment. So we'll just have to continue to watch that.
Indeed, we will. Andy, thank you very much. Andy McCarthy.
Hi, everyone. I'm Brian Kilmeade. I want you to do me a favor.
So, essentially what they're saying is, if we go back to this is how they want to stop Trump from getting back into office, right? So election day, November 5th, Super Tuesday. We got judges to sit in on New York civil business fraud trial. January 6th trial start date for the J6 trial. This is all pending right now. NYS hush money trial. Whatever. Republican National Convention is July 15th. Sandwich in between that is the classified documents trial. Whatever this March 5th one is, it's covered up by the closed caption. Then you got the Georgia 2020 election trial to be determined. All here. This is how you obstruct anyone from running for president. Is you say you don't have immunity, you can't challenge the results, and if you do, we're going to persecute you. Now, here's the last thing I'm going to say about the about all of this, and we're going to move on to new videos coming at you. If you like my takes on this, then hit that like, subscribe, and follow button. Share this out to your friends, because this is important stuff. You got DC judges appointed by the sitting president ruling on an appeal to his most his most favorable political opponent. And then you're going to sit here and say, oh, well, you can't challenge anything. And come January 20th, if you lose the election or your term is up, you're no longer president. You're now citizen, and you can be tried for any crimes you may or may not have committed while in office as president. All right. So what about Hillary Clinton's campaign denial in 2016? She was never president, right? She was just candidate Hillary. So why shouldn't Republicans or, conservatives file charges against her for her campaign denial, her election denial? What about Barack Obama's drone strikes that killed civilians? I mean, that's, if me and you would have launched a drone and killed civilians, we'd be buried under the jail. So why not charge him? Why not charge George Bush for the 20-year war in Iraq that killed thousands of innocent people? So why not charge him for that? Oh, well, we were at war. Well, that doesn't excuse the mishandling of troops, and it doesn't excuse the killing of innocent civilians in Iraq and Iran and Saudi Arabia. But hey, I guess losing a tower in New York, as horrible as that is, constitute, hey, let's go and kill tens of thousands of their civilians. Why not charge Bill Clinton? I mean, we can go back. It said it here that Trump is the first president ever in the history of our country to be charged with a crime after he left office. All right. Well, that's all I got for you. Common sense take says charge them all. Let's just charge every president. Let's just neuter the president in itself. And matter of fact, to hell with our constitutional republic, and I get tired. And just so everybody knows, I got 2 minutes. All right, 120 seconds. Here's a hot take for you. We're not a democracy. We're a constitutional republic. We use a democratic process to elect our governing body, to Senate, Congress, President, but we are not a democracy, okay? You can't subvert democracy when you're not one. We're a constitutional republic, which means we elect people to carry our voice into government, because if we were a democracy, could you imagine what is there, 170, 150 million, 170 million voters having to vote on every single law that wants to be passed? I can't get 10 people to agree what they want for lunch, much less getting 170 million people to agree on, laws being passed. So just keep that in mind whenever you hear all these people saying, my democracy, subverting the democracy. We're not a democracy. We're a constitutional republic, which means we adhere to a constitution. Now, if he's found guilty, then so be it. If he's found guilty in a legitimate court with legitimate evidence, then so be it. It is what it is. Nobody's above the law. And I agree with that. But this here has all the makings of a sham trial with appellate judges appointed by the sitting president to rule against his top political opponent. And that's my common sense take. So remember, everybody out there, let's keep common sense common.